Thank you, Mr. Speaker, sir, and thank you, distinguished senators. For the record, my name is Ongoya, representing the County Assembly of Kericho. I wish to begin by making an overall observation that after all the charges that were leveled and all the evidence particularized of impropriety against the governor chose not to take the witness stand and answer to any of those charges. The question is this: when a charge is leveled and the evidence, the quantity and weight of which has been played before you by way of witness testimonies, documentary evidence, and video evidence, and the person called to account refuses to take the opportunity given to him to account, what inference will you draw from that? When you begin deliberating, I invite you to consider that aspect of this case. Having said that, there are certain matters that arose in the course of clarification by senators that I wish to address myself to as part of these closing submissions. We stand here as lawyers, Mr. Speaker, sir, distinguished senators, as people who have to offer guidance on the harmony or otherwise between the evidence on record and the law established. The conclusions to be drawn from that evidence on record and the law established are purely yours as judges, and as participants in the justice process, we have no choice but to accept your verdict unless one pursues any other option known to law. So two questions arose, Mr. Speaker. Distinguished Senator Onyonka presented to the expert witness a question in the form of that both the passwords and the usernames to this system were made accessible to all MCAs. Mr. Speaker, sir, let the Hansard record me as saying that there is no such claim made by any witness before this assembly. The witness before this, the evidence before this Senate has been and remains this. 2 links were sent to MCAs. Link number 1 communicated IPPD numbers which were to be used as the user names. A username, to my lay understanding, is like my email address, which I put on my letterheads and put on my contact numbers, which is itself not a risk. The second link was the voting link. It went with the instruction that every individual MCA will use their own ID, national identification card numbers to vote, so that the aspect of the passwords were never communicated to everybody at all. I have been a participant in the processes of this House, both as an academic and as an advocate, as I'm doing, and I know that there is a rule in this House of accuracy of facts. Whenever one makes a decision, the accurate fact is that no witness, both from the governor's side or the assembly side or the expert, stated anything to the effect that people's ID numbers were communicated to everybody. It is important that that fact is captured by the record and the decision makers so that a decision is made on the correct set of facts. Secondly, a question arose from the clarifications as to whether there was a possibility of geolocation of these IP addresses. I can do no better, because I am no IT expert and cannot pretend to be one, than to look at this Senate's own appointed expert. At page 13 of that expert's report is IP address lookup. Page 13 of that is IP address lookup. Then it says geolocation data from, then there are some details there, but I'm interested in the country, Kenya, region, Kericho. I do not know what conclusion you can draw from that because I am no ICT expert, but the only evidence available to us shows some geolocation of this IP address to Kericho. I thought that is an important question for you to take into account. Allow me to then address the question that has now emerged as the question of the voting process. And let me observe this. Number one, whereas this House is not strictly bound by rules of evidence, this House, in fact, applies rules of evidence, by which I mean it does not completely disregard rules of evidence. That is why witnesses swear their affidavits as required by rules of evidence. Witnesses take the witness stand and are sworn as required by rules of evidence. Witnesses are examined in chief as required by rules of evidence. Witnesses are cross-examined as required by rules of evidence. Witnesses are re-examined as required by rules of evidence. So the point I'm making is that whereas you are not strictly bound by rules of evidence, your rules don't disregard rules of evidence. There is a presumption in evidence law called presumption of regularity. That when you are presented with official documents, Kenya Gazettes, official government reports, you presume them to be regular until credible evidence to the contrary is proved, is presented. The County Assembly has presented you evidence of 33 MCAs voting for the impeachment of this governor. The County Assembly has given you an expert witness who has said, as far as is concerned, these 33 MCAs voted for the impeachment of this governor. The governor has presented an expert here. That expert has not controverted that factual content of the official document, the Hansard, that in fact 33 MCAs voted for this governor. This Senate, faced with those two witnesses, has called its own ICT expert. That ICT expert has returned a verdict that from the information available to him, in fact, 33 MCAs voted for the impeachment of this governor. It forces, therefore, it demands, therefore, us to conclude that no evidence has been presented that challenges the Hansard of the County Assembly and the resolution of the County Assembly that 33 MCAs voted for the governor. Let us look at the attempts to challenge that position. First, the records will show you that the governor's claims before you were premeditated claims. He entertained these claims in advance of the voting process. His advocate is captured in the Hansard of the County Assembly saying, we know that people have voted for or will vote for 4 members of the County Assembly. This was said in advance of the voting. Let us look at this carefully. An MCA comes and tells you that 18 MCAs left their phones in the car. The MCA who came here, Honorable Anita Mibei, confirms she had her phone inside the chamber. It means the allegation that these MCAs left their phones inside the car is not worth of any credit. That's what it logically means. She introduces a new nuance of her phone going off, which was not contained anywhere in the affidavits she presented before this House. All MCAs who came here confirmed that they were all in the house. All the 47 MCAs were present in the house. All the MCAs were given an opportunity to vote. The Speaker announced that all of you have an opportunity to vote. And here is the voting method. And if any one of you has difficulties, go to the gadgets presented to you by this assembly and be assisted to cast your vote. No MCA says, I attempted to cast my vote as guided and anyone frustrated me. No MCA says so. The governor makes a claim that 4 MCAs did not in fact vote. The system returns them to have voted. One of those 4 MCAs comes before you with another affidavit. She's called Edna, and says, in fact, the contents of the other affidavit is wrong. In fact, I voted, and in fact, I never signed the other affidavits. What is the net effect of this development? The net effect of this development can only be one: distinguished senators, and that is the claim that these 4 MCAs did not vote is not believable. That's the only conclusion you can draw. So, let us face this. The governors, I'll come to that in a short while and I'll begin analyzing those witnesses one by one. But let me address you on the lack of logic in the totality of the governor's case theory. There were 47 MCAs entitled to vote in Kericho County Assembly on the 15th of August, 2025. If you believe, as the governor believed, and as his council believed, that someone voted for you with your credentials, the logical thing is to attempt to log in with those credentials and say, I was unable to log in because somebody had already used them as passwords to log in. That's the logical thing. The other logical thing, if you believe that the system was capable of double voting, is to log in and vote yourself. Because once you log in and vote yourself, and somebody else has double voted, the system will return more votes than the registered voters. That's the logical thing. So I do not know, Mr. Speaker, sir, distinguished senators, whether we have a case of imprudence or dishonesty on the part of these witnesses. But I want you, when you consider this matter in your own debate, to tell me how somebody will fail to take advantage of these 2 possible and irrefutable evidence creating acts and come and present another one to tell you, I did not vote. And let's face it. These are the very MCAs you saw by your own clip. The governor's council at the assembly telling them, stand up and demonstrate you will vote support the governor. One of them says they had met the governor earlier and they had agreed on that position. First, that is legislative impropriety. Will you believe a representative of the people who confesses to have engaged in that conduct? I am inviting you to find the overall conduct of these people to be not worth of your credit. But let me point out something else. Mr. Peter Wanyama, advocate for the governor, says, in fact, he logged into this system twice and voted. The county assembly's expert has not seen that login of his. The governor's own expert today has confirmed he didn't see that login by Peter. The independent expert by this house has confirmed he didn't see that login by Peter Wanyama. It means The governor's case theory is found on a shameless lie that an advocate of the High Court of Kenya, and our profession, Mr. Speaker, sir, thankfully for me, you belong to this profession, and distinguished senators, some of you belong to this profession, abhors an advocate vouching for his client. An advocate presents evidence as presented by witnesses and the law established. But if the advocate himself can take the extreme stance taken by Mr. Peter Wanyama Learned Counsel to present a factual wrong that he logged in this system and voted, a fact which his own witness says, I didn't see it in the logs, a fact which the independent witness of this house, the expert, says, I didn't see that in the logs. A fact which Mr. Peter Wanyama himself was unwilling or unable to take the witness stand and be cross-examined on. I invite you to draw a conclusion that there is enough evidence that the governor was willing to go to any extent to deceive this house, that this voting process was in fact compromised. Let's face it, distinguished senators. Every system, ICT or otherwise, can be made better. Any system can be made better. Banks work on ICT system, and many other systems now, operations work on ICT systems. Whether they medical systems, they aviation industry systems, and all other systems. Each one of them can be made better. The fact that the system adopted by the County Assembly of Kericho can be made better is not a basis for invalidating that which it has done. The only basis for invalidating that which it has done is credible and irrefutable evidence that the system was in fact compromised, not capable of being compromised. No single witness before you has brought that evidence that this system was in fact compromised. Learned Senior Counsel, Mr. Katwa Kigen, I would reiterate, Mr. Speaker, sir, one of the most courteous counsel that I know, one of the most polite counsel I know, and a mentor to many young lawyers that I teach, came here and this, in his opening remarks, which are captured at page 25 of Wednesday this week morning, observes that this site was pulled down, and in a response to the PO, it was brought up again. The logs by these witnesses would have shown that act of pulling down the site and re-uploading the site. Not the County Assembly's witness, not the governor's witness, not the independent witness of this Senate has captured that log of interference with this site by pulling it down and re-uploading it. I am reiterating a simple and straightforward case that this evidence shows that this governor could go to any extent, including getting senior and reputable counsel to present factual inaccuracies before this Senate just to achieve the termination of these proceedings on a technical objection. As you vote on this issue, I beseech you to debate these questions, and if you reach answers contrary to these submissions, I will leave with your verdict peacefully. If you reach a verdict that conforms to this verdict, once again, I will be able to live with it peacefully. Look at how the county governor's council stood before the county assembly and the governor himself and commandeered, assumed the speaker's role, commandeered the MCAs stand up. What had they done to those MCAs to assume that kind of control over them? I am not sure that if I stood before here and commanded these senators to stand up in direction, they will take it seriously, however persuasive my case. What had they done to them? Between this system that provided some form of privacy for the individual MCA and the so-called roll call system, in that context of this governor and this advocate commandeering MCAs on record, which one would have guaranteed better integrity and independence of decision-making by this assembly? It is expected that any MCA who took advantage of that semblance of independence and voted for this motion, having been earlier intimidated and commandeered, may consider stating that they had not voted. In the next few minutes, let me reflect on the question raised by the majority leader on the 3 MCAs. For starters, distinguished senators, there were 4 who took that position as represented by the governor. Along the way, my learned colleague, Mr. Katwa Kigen, confirmed one of them abandoned that position. This position that we did not vote, which witnesses are liberally taking and abandoning, can we take it as a definitively confirmed position that witnesses didn't vote? Because they are taking and abandoning. That's number 1. Number 2, let's look at the residual 3 that are of concern to the question raised by the majority leader on behalf of the House. One of them is Martin Kiplangat Cheruyot. First, you'll notice that Martin Kiplangat Cheruyot swore the same affidavit with Edna Tonui. Same affidavit. They jointly signed it as we. Edna Tonui has now told us, I never signed that affidavit by her own affidavit. On what basis would we believe that affidavit where one of the owners has disowned? It is said, Mr. Speaker, sir, distinguished senators, that if the alligator came from the sea, systems do this. An expert told to audit this system can recommend some things that can make this not to happen. It does not mean that what we are doing here is invalid. What we are doing here remains valid regardless of this kind of systemic challenges. So I'd said, it is said that if an alligator came from the sea and told you, Mr. Crocodile is sick, you don't say, I am going to the sea to verify for myself. In regard of the affidavit jointly sworn by Edna and Martin Kiplangat Cheruyot, the alligator that has come from the sea, symbolically speaking, and with due respect, is Edna. She has told us that affidavit is fake. That signature is not mine. How much more evidence do we need to discredit that affidavit? Then comes the other joint affidavit of the 18 MCAs, on which, again, Edna's name is indicated. She has come from the sea and told us that affidavit is fake. I didn't sign it. Why would we believe anything from that affidavit? So that would be the approach, Majority Leader, distinguished senators, if I were confronted with that evidentiary question. But that is not enough. That is not enough. Consider the evidence of Amos Birir Trump, who is asked a simple question, Mr. Speaker. This affidavit you claim to have signed jointly, the 18 of you, what time did you sign it? Daytime or nighttime? He says he signed it after lunch. It turns out the assembly proceedings went on until past 8 p.m., and that affidavit contains proceedings of the assembly, meaning it could only have been signed in the night. Normal advocates would have closed their offices at that time. They would tell their clients to come back tomorrow. Can we believe that witness who says those things? I say this because what is before you is whether you have credible evidence to disturb the presumption of regularity of the county assembly's Hansard and resolution as communicated to you. Let's then look at this Amos Birir, the Trump. He came here as an old man, stated his age, and initially looked very credible, even to me, initially. When confronted by learned colleague, Mr. Mutuma, in cross-examination, I do not know what your assessment of him was. Let me just say, in my assessment, he struck me as an old man, yes, but not very honest. Simple facts as to whether he has an internet-enabled phone, whereas his affidavit gave us an impression that he had no internet-enabled phone, he was on WhatsApp. In fact, that number, which he said was in the phone he was carrying in this house, was itself on WhatsApp. I do not know how much more credibility you can give such a witness. He needs redemption in the area of credibility, if you sought my opinion. The verdict belongs to you, as whether you will believe him. A witness called Hilary Kibet Bosuben confirmed that he had a laptop supplied to him by the county assembly. He confirmed to him that he used this integrated system. Remember, voting is just one of the components of this system, but this system discharges multiple other functions. He used this same system to make his requisitions for payment of allowances for committee sittings, to register his attendance at committee sittings. It's these same people who use this system to register their attendance in committee sittings who are saying they have never been trained on this system. Fortunately for us, none of them claim to be missing out on their sitting allowances because of this system. It's enabling them in their bread and butter matters. It is only when voting is concerned that they draw the line. I then pose the question, are these the people, distinguished senators, whom you will say that you believe them that they didn't vote? Because to disturb the verdict of this assembly, you must reach a conclusion that, in fact, these people did not vote for the motion. At that juncture, credibility becomes the most important question. As you consider this motion, distinguished senators, remember Geoffrey Bett. Geoffrey Bett appeared before you as a person living with a disability, a mobility-related disability. He poured his heart out to you. He told you, I have come before you as part of my healing process. He told you, this governor confronted me in a joint sitting of the CECs and COs. He told you in that joint sitting of CECs and COs, when I was proposing to him that rather than procuring a financial management system at 68 million shillings, we can internally develop it at about 1 million shillings and prudently use taxpayers' money. He told me, I thought you only had a physical disability of your limbs. Kumbe, you also have a mental disability. Those were the words of Geoffrey Bett here. Geoffrey Bett has told you, I have come to this Senate as part of my healing process. I want you to consider Geoffrey Bett as you vote. Will your vote to rescue this governor aid Geoffrey Bett in healing? Or will your vote to save this governor add insult to injury to Geoffrey Bett? That issue is on trial before the Senate. Given a chance to take the witness stand, defend himself, and possibly address Geoffrey Bett wherever he is and say, Geoffrey Bett, before this same forum you sit, I am sorry for what I did to you. The governor has chosen not to take that stand. allegations of financial impropriety, particulars of which were laid before you by various witnesses and documents, and which have been summarized by the learned counsel who came before me, are clear that Kericho County is hemorrhaging in loss of public funds. The governor had two opportunities. One, to get his concerned officers, CECs, COs, procurement officers, to swear affidavits and shed light on these matters. I invite you to reach a conclusion that the failure of the governor to call those witnesses to come before you and give account constitutes his shielding of those witnesses. A governor who shields witnesses who spend taxpayers' money, as we showed you on the Kipkelion housing saga, who shields his officers who spend money, as we showed you, in respect of the Londiani unfortunate accident victims, cannot claim it is not my act. He must take the ultimate responsibility, at least, for shielding those officers. Secondly, given a chance to come and take the witness stand and explain himself, because the evidence we have shows irrefutable evidence of hemorrhaging of public funds, he has declined to take the witness stand. I invite you to conclude that the act of the governor to refuse to take the witness stand, when the time there showed that the governor still had slightly over 30 minutes of his defense, is an act of arrogance on his part, not warranting any mercy from you. If you take all these factors into consideration, my invitation would be, you can only do one thing, the right thing: impeachment of this governor. The County Assembly of Kericho has done its part. The Hansard of this house, as a historical record, will document that. Fortunately for me, the check is still open for you to sign. The history book is still open for you to record your position in that history. The Hansard is still recording you. It will record your vote. Distinguished senators, how will history document you individually and collectively regarding the side of history you belong to? The side that dignifies Geoffrey Bett, or the side that undignifies him? The side that protects taxpayers' money, or the side that does not? I am done with my part. The ball is in your court. I rest my case.
Counsel for the governor, the floor is yours. And your 60 minutes start running from now.
Thank you, Mr. Speaker. Mr. Speaker, honorable senators, my colleague, for the record, my name is Wajiko Diong. I will commence the closing argument, then my two colleagues will come thereafter. Honorable senators, our point of departure is the sequence of events as prescribed under Section 33 of the County Governments Act. And definitely, as we sit here, it's not in dispute that the County Assembly has the jurisdiction, the first jurisdiction, or the first instance in moving a motion for the impeachment of the governor. However, Mr. Speaker, in doing so, they must do so within the confines of the law and the edicts of the Constitution. They must adhere, in the very least, to Article 10, the principles and values of governance,